All rise! The bailiff's voice echoed through Federal Courtroom 24, cutting sharply through the low murmurs and rustle of papers. Every person in the room stood as Judge Richard Lyon strode in, his black robe flowing like a gathering storm. His face, set in granite, carried the same intensity that earned him his infamous nickname across legal circles, the Hammer. Known for his blistering cross-examinations and merciless intolerance for unprepared lawyers, Lyon had the unnerving ability to dismantle a career with a single sentence. But today, even by his standards, the air around him seemed heavier, charged with impatience. "The Wilson voting rights case," he announced curtly, his voice slicing through the silence as his piercing eyes scanned the courtroom. "Let's not waste time." The state's attorney rose confidently, buttoning his immaculate suit, already tasting victory. Cases like these almost never went against the government. The script seemed pre-written until Jasmine Crockett stood. At just 38, she appeared almost out of place before this legendary judge, young, unassuming, and vastly outnumbered. Most in the gallery doubted she had a prayer. Against the state, against the statistics, against the tide, she looked like a lone swimmer in a storm. Yet her calm presence betrayed something different. Crockett approached the podium carrying a single worn manila folder. No army of paralegals, no towers of exhibits, just that folder, clasped in steady hands. Across the aisle, opposing counsel smirked, the look of a man who'd already written tomorrow's headline. Judge Layon's eyes narrowed slightly. Then Jasmine spoke. Her first words fell like a pin drop in a cathedral. Conversations died mid-whisper. Even the air seemed to hold its breath. The judge's face shifted almost imperceptibly, from irritation to intrigue. His gaze locked on her as though she'd just upended something he thought he understood. The state's attorney's grin evaporated. The gallery leaned forward. "Your Honor," she said firmly, pulling a single sheet of paper from her folder. "Before I begin, I'd like to submit evidence that will fundamentally alter the court's understanding of this case." The document trembled slightly in the air, not from her, but from the ripple it sent through the room. What she revealed next would not only rattle that courtroom, but reshape the conversation around voting rights in America for years to come. The Wilson versus State Election Board case had begun quietly months earlier, after new voter ID laws barred nearly 200,000 citizens from casting ballots in the last election. On paper, the rules appeared harmless, a simple requirement for government-issued photo identification, something that sounded reasonable to most voters. But buried beneath that neutrality was a brutal imbalance. In predominantly minority counties, DMV offices had shuttered, operating hours were slashed, and many had been relocated far beyond bus routes. For working families, obtaining an ID meant losing a day's pay, arranging childcare, and traveling 40 miles or more each way. The impact was staggering. Westwood County saw voter turnout collapse by 63%. In communities like Eastern Heights, polling stations reported hundreds of longtime voters turned away, people who had faithfully shown up for decades. "I've voted in every election since 1964, said James Wilson, a 78-year-old veteran standing outside the courthouse steps. "I fought for this country, paid my taxes, and now they tell me my VA card doesn't count?" Wilson, who had walked 3 miles only to be denied his ballot, became the lead plaintiff. Judge Richard Lyon was no ordinary federal judge. At 72, his presence commanded both reverence and fear. Appointed in 2002 by President George W. Bush, he built a reputation for brutal honesty and surgical precision. He had once struck down the NSA's phone tracking program, calling it borderline Orwellian, yet had upheld other controversial policies when the law demanded it. Lawyers studied his rulings as scripture. Because Lyon didn't follow politics, he followed logic. His clerks had given him his moniker, the Hammer, not for volume, but for accuracy. He dismantled weak arguments with the calm certainty of a craftsman setting a nail in one blow. "If you walk into Judge Layon's courtroom unprepared," one attorney warned, "you may as well hand over your brief and walk out." His memory for case law was near perfect. Bluffing was suicide. Many attorneys had left his courtroom red-faced, their reputation shredded by a single question. Across from him stood Jasmine Crockett, a woman whose path to that courtroom was anything but conventional. Raised in South Detroit by a single mother who sorted mail for the Postal Service, Jasmine had worked graveyard shifts and scraped through law school, earning every inch of her success. Unlike the polished attorneys who usually filled federal benches, she had spent her career representing the people who couldn't afford representation at all. Before this case, her name was known in small circles for freeing wrongfully convicted defendants, her victories built not on power, but persistence. In one case, she unearthed evidence buried beneath thousands of police reports, clearing an innocent man after 12 lost years behind bars. This fight, however, was unlike anything she'd faced. It wasn't just about law. It was about the balance of power itself. The state came armed with a 6-member team from one of Washington's most elite firms, led by Bradley Thompson, a man who had argued before the Supreme Court 7 times without a single loss. Their brief spanned 378 pages, dissecting every inch of Crockett's argument. Hers? Just 42 pages long. But what no one in that courtroom yet understood was that Jasmine Crockett wasn't playing by their rules. While most civil rights lawyers leaned on sweeping rhetoric, she had spent 6 painstaking months rebuilding her case from the ground up, not from theory, but from truth. She had personally visited every district affected by the new law, collecting 358 first-hand accounts from voters who had been turned away. She matched their stories against census data and DMV maps, revealing a chilling pattern, a pattern hidden behind policy. Her most damning discovery came not from testimonies, but from inside the government itself, thousands of internal emails obtained through Freedom of Information requests. For 3 relentless weeks, Jasmine worked 18-hour days, combing through nearly 12,000 documents until she uncovered something no one, not even the state, knew existed. That morning, the courthouse was packed to the rafters. Civil rights leaders sat shoulder to shoulder with ordinary citizens whose futures hung in the balance. Reporters lined the walls, cameras poised, the murmur of history in the air. Everyone sensed that this was more than a trial. It was a turning point. When Judge Lane entered and called the court to order, silence fell like a blanket. Not a single person in the room yet realized they were about to witness one of the most consequential legal showdowns of their time. A clash that could redefine how America understood voter access and equality for generations. The bailiff's voice rang out again. All rise. The United States District Court for the District of Columbia is now in session. Judge Lane took his seat, eyes sharp, his tone unyielding. You may be seated, he said. We are here to hear oral arguments in Freedom Access Project vs. Brennan Election Commission. Ms. Crockett, you may proceed. Jasmine Crockett stepped forward, poised and unwavering. The click of her heels echoed against the marble like a metronome of resolve. She placed a single binder on the podium but barely touched it. Thank you, Your Honor, she began, her voice steady, deliberate. This case asks a simple but fundamental question. Can a state impose voting rules that appear neutral yet inflict discriminatory harm in practice? She paused. Every eye followed her. The Supreme Court has long recognized that the right to vote is the foundation of all other rights. When that foundation cracks, democracy itself begins to crumble. Judge Lane leaned forward, listening intently. The state insists these ID laws prevent fraud, she continued. Yet, over 10 years and 14 million ballots, there were only 7 proven cases of in-person voter fraud, a rate of 0.05%. The judge interrupted. His tone clipped. Ms. Crockett, even rare fraud is still fraud. The court in Crawford versus Marion County affirmed that fraud prevention remains a valid state interest. Most attorneys would have stumbled there. Jasmine didn't. You're absolutely correct, Your Honor, she replied smoothly, catching him off guard. Crawford did affirm the state's interest, but it also established a balancing test, whether the state's concern outweighs the burden imposed on voters. She reached for a folded map. With the court's permission, I'd like to show you something. The judge nodded, She unfolded a large color-coded map of the state. The red zones, she explained, represent districts where over 30% of voters lack valid photo ID. The blue dots are DMV offices where those IDs are issued. Notice anything, Your Honor? In the darkest red regions, there are almost no blue dots. Leon's eyes narrowed as he leaned closer, studying the pattern. And your point, Counselor? He asked. My point, Your Honor, Jasmine said, her tone unwavering, is that voters in those red districts, mostly minority communities, must travel up to 175 miles round trip to reach an open DMV. For many without vehicles, that's a 3-hour bus ride each way, assuming bus service even exists. The few offices available operate only 2 days a week, from 9 to 4. Hours that force working families to choose between a paycheck and their right to vote. The state's attorney, Michael Reynolds, abruptly stood. Objection, Your Honor. The inconvenience of travel doesn't rise to a constitutional violation. Judge Lean turned to him sharply. This is not a trial, Counselor. You'll have your turn. Sit down. Then, with a glance back toward Crockett, he said firmly, Please, continue. Crockett gave a respectful nod and pressed forward, her calm presence commanding the full attention of the courtroom. Thank you, Your Honor, Jasmine began, her tone steady but firm. In Harper v. Virginia Board of Elections, the Supreme Court ruled that no state may impose any cost, direct or indirect, on the right to vote. While this state may not be charging a fee for the ID itself, our economic analysis shows that the real cost, including lost wages, transportation, and obtaining required documents such as birth certificates, averages about $175 per voter. She continued to build her argument slowly and deliberately, layering each point like bricks in a wall. Every potential counter-argument was anticipated and addressed before Judge Leon could even voice it. For nearly 40 minutes, Crockett moved through intricate areas of constitutional law, referencing landmark precedents that spanned several decades of voting rights cases. Judge Leon, known for his quick interruptions, unrelentless hypotheticals, found himself listening more than speaking. When he did interject, his questions were met with precise, unflinching answers that reflected not only preparation but mastery. The courtroom sensed it. Something extraordinary was unfolding. Then came the question that would shift the entire momentum of the case. The judge leaned forward. Miss Crockett, he said, let's assume a hypothetical scenario. Suppose the state assigns polling stations based on the last 4 digits of each citizen's social security number. Now, if this system on its face seems neutral, but ends up forcing minority voters to travel twice as far as others, with no evidence of intent to discriminate, would that violate the Constitution? The room went silent. It was exactly the kind of complex hypothetical that had trapped many lawyers in his courtroom before. Crockett paused for a moment, gathering her thoughts. Your Honor, she replied calmly, that situation mirrors the logic of Gillian v. Lightfoot. In that case, a city redrew its boundaries in a way that excluded 99% of black voters without mentioning race in the statute. The court still struck it down, recognizing that a law can appear neutral yet produce a discriminatory outcome. She took a breath, then pivoted unexpectedly. And Your Honor, your hypothetical actually highlights something critical about this case. The state is effectively arguing that as long as race isn't mentioned directly, any level of disparate impact is permissible. That logic is fundamentally at odds with both precedent and principle. Then she surprised everyone. May I approach the bench again? She asked. Judge Lean, visibly intrigued, nodded. Crockett retrieved a printed email chain from Hurtable and handed copies to both the judge and opposing counsel. This, she said, is an internal communication between the state's election commissioner and the consultant who drafted these ID rules. Please look at page 3. The courtroom buzzed as the judge began reading. The beauty of using these specific criteria, the consultant had written, is that they disproportionately affect demographic group A while allowing us full deniability since race is never mentioned explicitly. A ripple of shock spread through the gallery. Judge Leon's eyebrows rose slightly. And how did you obtain this document, Miss Crockett? He asked. Through standard discovery procedures, Your Honor, she replied. It was among the 50,000 documents turned over by the state. I doubt they realized it was there. It was buried deep in a section labeled Database Technical Appendices across the aisle. The state's attorney, Michael Reynolds, flipped through his copy frantically, his expression draining of color as he located the damning sentence. This case, Crockett continued, isn't only about disparate impact. It's about intentional discrimination disguised as neutrality. The Supreme Court's Arlington Heights framework exists precisely to expose this kind of hidden bias. The atmosphere in the courtroom changed entirely. What had begun as a routine constitutional hearing now felt like a moment of history unfolding in real time. The spectators leaned forward. Even the clerk seemed transfixed. Judge Lean read the email again, slower this time, his face tightening in thought. For a long moment, the only sound was the quiet hum of the air conditioning. Finally, he looked up, his tone more measured. "Miss Crockett," he said, "you've presented substantial evidence of intent. But even assuming discriminatory purpose, the state argues that its regulations still survive strict scrutiny because preventing voter fraud is a compelling governmental interest." The tension in the room deepened. This was the final test of her argument. Every eye was on Jasmine Crockett as she stood silent for a beat, then began her reply with quiet authority. "Your Honor, for any law to withstand strict scrutiny, it must be narrowly tailored to serve a compelling interest. These ID laws fail that test for 3 clear reasons." She lifted one finger. "First, they are not narrowly tailored. Our analysis shows that 94% of the burden falls on minority communities to solve a problem in-person voter fraud that statistically does not exist." A second finger. "Second, there are at least 16 less restrictive alternatives that could achieve the same anti-fraud purpose without disenfranchising lawful voters. Those alternatives are detailed in our brief, a third finger. And finally, the newly uncovered email proves that fraud prevention was never the real motivation. When the justification is pretextual, strict scrutiny cannot be satisfied." Then came the moment that would dominate headlines for weeks. "Your Honor," she said with the court's permission, "I'd like to present one final piece of evidence obtained only yesterday." Judge Lean gave a slow nod. Crockett handed a sealed envelope to the clerk, who brought it to the bench. As the judge opened it, his face shifted curiosity, giving way to disbelief. Inside was a confidential memorandum from the state's own election security division dated just 2 weeks before the new ID law was announced. The report stated plainly, "After a comprehensive review, we find no evidence that in-person voter impersonation presents any meaningful threat to election integrity." A collective gasp spread through the courtroom. Even Judge Lean's expression softened from stoic neutrality to visible astonishment. Resources should be focused on fixing the real weaknesses in the election system. Especially in cybersecurity, Judge Lean lifted his head, eyes widening. "This completely undermines the state's main claim about why these regulations exist." "Yes, Your Honor," Crockett replied confidently. "The Commission ignored its own security team's report because the real goal behind these regulations was never preventing fraud." The state's attorney, Michael Reynolds, quickly stood. "Your Honor, we've never seen this document before. We object to its late submission." Judge Lean gave him a sharp look. "Mr. Reynolds, this appears to be your client's own internal memorandum. Are you suggesting the Commission withheld this during discovery?" Reynolds hesitated. "I'd need to check with my client." "I suggest you do that immediately," the judge said coldly. "This court takes discovery obligations extremely seriously." Turning back to Crockett, Judge Lean examined her closely. The room was silent. Everyone could sense something rare was unfolding. Known for his emotionless expression, Judge Lean now seemed deeply moved. "Miss Crockett," he said, his voice echoing through the courtroom, "in my 30 years on this bench, I've never seen reasoning of this level. You've just reshaped how this entire case must be viewed." The statement sent ripples through the courtroom. Legal analysts would later say they had never heard Judge Lean offer such open praise during a hearing. Yet what happened next was even more powerful. Instead of soaking in the compliment, Crockett responded calmly, "Thank you, Your Honor, but this case isn't about legal brilliance or individual performance. It's about the constitutional right of every American to vote freely without man-made barriers designed to suppress their voices. The 150,000 citizens who've effectively lost that right deserve this court's protection far More than I deserve any recognition. Her words instantly shifted focus from herself back to the larger principle at stake. Several spectators nodded quietly in agreement. Judge Lean leaned back, Asmal's smile breaking across his face. Well said, counselor. Well said indeed. He turned to the state's attorney. Mr. Reynolds, it appears you have some serious work ahead. Proceed. Reynolds walked to the podium. Clearly shaken, his earlier confidence was gone as he fumbled through his notes. Your Honor, while Miss Crockett's remarks were indeed impressive, she misrepresents the state's position and the relevant law, but his argument faltered. Judge Lyon interrupted repeatedly with sharp questions. Mr. Reynolds, how do you defend your fraud prevention claim when your own security team concluded in-person fraud is virtually non-existent? How do you explain the internal email discussing how to target particular demographic groups using neutral criteria? And with only 0.005% of votes showing any sign of fraud, how can this regulation, which affects 17% of eligible voters, be considered narrowly tailored? Reynolds struggled to respond. By the time he finished, the outcome seemed clear to everyone in the courtroom. When Crockett stood for her brief rebuttal, her quiet but steady tone filled the chamber. Your Honor, this case isn't about complex legal theories. It's about whether the Constitution allows a government to make voting harder for some than for others. The evidence and proceeding make the answer plain. It does not. As she gathered her files and sat down, the courtroom remained silent. Everyone knew they had witnessed something historic. Not just outstanding advocacy, but a defining moment in the fight for voting rights when Jasmine Crockett exited the courthouse. She was surrounded by cameras and reporters eager for her response. Miss Crockett CNN, what's your reaction to Judge Lean's remarkable compliment? One asked. She paused thoughtfully. What matters isn't praise for me. What matters is whether the court defends the rights of voters silenced by these unfair rules. This case has always been about them. Her answer quickly went viral, earning praise for keeping the focus on justice rather than personal credit. Behind closed doors, the state's legal team scrambled. Reports soon surfaced that emergency meetings were underway to discuss a possible settlement before Judge Lyon could issue a likely devastating ruling. Legal experts across party lines agreed what happened in that courtroom had changed everything. Harvard law professor Lawrence Tribe shared his reaction on social media. What Jasmine Crockett accomplished today wasn't just skilled advocacy. It was a masterclass in constitutional law that future generations of lawyers will study. Even prominent conservative scholars couldn't deny the power of her performance. Former Solicitor General Paul Clement remarked on a legal podcast, no matter your political stance, the level of advocacy Ms. Crockett displayed was extraordinary. She broke down the state's position piece by piece, using precedent and evidence with surgical precision. 3 weeks later, Judge Lyon released his ruling, a detailed 87-page opinion granting a preliminary injunction that stopped the controversial voting regulations from taking effect. His opening lines were unusually direct. This case is a textbook example of regulations that, though neutral on paper, were intentionally designed to restrict the voting rights of minority citizens. The evidence of discriminatory intent is overwhelming, and the state's justifications cannot survive constitutional review. Judge Leon's decision reshaped how courts evaluate election laws that disproportionately affect minority communities. He wrote that when voting rules place heavier burdens on certain groups, judges must look beyond official explanations. Internal communications, data showing unequal impact or contradictions between public statements and internal reports can reveal unconstitutional intent. Even without any explicitly racial wording, the decision sent shockwaves through legislatures nationwide. Within days, 5 states announced plans to evaluate similar laws. Voting rights organizations across more than a dozen states filed new challenges, citing Judge Lean's opinion as persuasive authority. For thousands of voters, the effects were immediate. The state was ordered to halt its strict ID rules and create a fairer system, ensuring equal access to the polls. In the next election, voter turnout in previously restricted areas surged by 31%. 2 months later, Jasmine Crockett was invited to deliver the keynote address at the American Bar Association's annual Civil Rights Conference. Her speech titled Constitutional Advocacy in the Modern Era became required viewing in law schools across the nation. The Constitution's promises don't fulfill themselves, she told the packed hall. They depend on advocates willing to connect abstract principles with real lives. When we let technicalities outweigh fundamental rights, we betray the very document we claim to honor. Her closing message would be quoted by future generations of attorneys. The strongest weapon in constitutional advocacy isn't eloquence or ideology, it's preparation. The quiet, disciplined work of mastering facts, understanding precedent, and anticipating every counter-argument before stepping into court. That work happens long before the cameras roll. But when the moment arrives to defend someone's rights, that preparation becomes true power. Perhaps the most meaningful praise came from Judge Lean himself. In a rare post-decision interview with Legal Times, he reflected, "Judges are supposed to be guided by law and facts alone. But sometimes an advocate presents them with such clarity that it deepens your understanding of the Constitution itself." Miss Crockett's case was one of those moments. The ruling's greatest impact was not in Washington, but in communities nationwide. In the years after Judge Lyon's opinion, states were forced to revisit voting procedures that had unfairly hindered minority, elderly, and disabled voters. Access to the ballot expanded. Participation rose. Democracy became more inclusive. Law professors now teach Crockett's case alongside landmark voting rights. Precedents and constitutional law textbooks include excerpts from her oral arguments and Judge's ruling. A new generation of young lawyers studies Crockett's technique, her precision, calmness, and command of both law and principle. For Jasmine Crockett, the case became both a defining milestone and a springboard for greater influence. She continued championing civil rights, focusing on voting access, criminal justice reform, and economic fairness. Yet, she never lost touch with the communities she represented. When a journalist later asked if she saw herself as a legal celebrity, Crockett smiled. "No," she said. "I see myself as someone doing the work that must be done. Millions of Americans still face barriers to their rights. My job is to use whatever skill I have to protect them." The lesson from that unforgettable courtroom day was never about fame or applause. It was about the quiet strength of preparation, the courage of moral conviction, and the power of principle in action. One person armed with knowledge and purpose can still reshape the law and history itself. For those who watch that moment unfold, the memory remains etched in time. A silent courtroom, a brilliant advocate, a moved judge, and the Constitution defended with grace and determination. For the thousands whose right to vote was restored, the impact endures the simple, powerful ability to stand as equal participants in American democracy. If this story of courage and advocacy inspired you, don't forget to like this video and subscribe to our channel. We bring you powerful courtroom moments that are transforming the fight for justice and protecting the future of constitutional rights. Share this story with anyone who believes preparation and principles still matter in the pursuit of truth.